Good afternoon, everyone. Thank you so much for being here. My name is Jackie Muick, Advocacy and Communications Administrator for Maryland Realtors, and I want to welcome you to our Legal Forms Update webinar for 2025. Today we have with us our Director of Legal Affairs, Kim Link, Senior Associate Counsel, Cleo Pappas, and last but certainly not least, Associate Counsel, Taylor Kitzmiller. Together, they will delve into contract language changes, new revisions, and other laws going into effect on October 1st. We do encourage your questions and we look forward to answering them. Please post questions in the Q&A box below at the bottom of your Zoom screen. This webinar will be recorded and posted on our YouTube page for future reference. We will also email that link out to all of you and all registrants for this webinar. And with that, I'll turn it over to Taylor. Take it away.
Thanks, Jackie. All right, good afternoon, everybody. I'm Taylor Kitzmiller, Associate Counsel with Maryland Realtors. And today we are going to go over all of the new upcoming changes to our forms that will be released officially on October 1st. I staff our statewide forms committee, and they've been working very hard over the course of the last year to finalize these changes to make sure our forms are in a place where they can best serve all of our members. Just a little background of how these changes are made. I would say that the majority of the changes that we eventually make to our forms come from member proposals. So any one of our members can reach out to us, call us on the legal hotline, send an email into Maryland Realtors, and present a proposal to maybe change an existing form, maybe create a new form, and then we take those proposals, present them to the statewide forms committee for discussion, and eventually they're put to a vote. So that's how most of the form changes are made outside of member proposals. The other changes we make typically are because of changes in Maryland law. So as we all know, Maryland General Session is in the beginning of every year where new laws are passed. And sometimes those new laws require us to create a new disclosure or add new language into our existing contracts so we can make sure that they're up to date and compliant with Maryland law. One major thing to note, on our website, we have at the top of our statewide forms page, you will have access to all of these sample versions of the forms that we will go over today, as well as the summary of changes and practice tips, which I'll show in a second, but essentially it is just a written summary of all of the changes that we're going to go over in today's session. Just one other thing to note, if you have, where we encourage questions, you can pop them in the chat. If your question is very transaction specific and it's going to take some diving into to answer your question, please do not put it in the chat. Please feel free to reach out to our legal hotline. That's the best place for you to submit that question for us to give you a proper answer, to take the time and sit down and go over it with you. Okay, and with that, I will share my screen and we can get started. One of the positives this year is the amount of form changes we have compared to last year. It's night and day. As I'm sure everybody knows, last year following the NAR settlement, we had a bunch of brand new forms. We had major changes to our existing forms, brokerage agreements. This year, thankfully, for the most part, pretty minor changes to our forms. And there's probably 6 or 7 forms that were changed and only one brand new form. So compared to last year, it's going to be hopefully a walk in the park. All right. So as I referenced earlier, this is the summary, October 2025, summary of changes and practice tips, which goes over all the changes that we have made to our forms. The first form we're going to go over is the only new form this year. It is the pet rent addendum. So this new addendum is an optional addendum that can be added to our general residential dwelling lease template. It's an agreement between the landlord and the tenant, authorizing the tenant to keep a pet or multiple pets on the property. And in exchange, the landlord has the option, there's no requirement for the landlord to do this, but the landlord has the option to require the tenant to pay monthly pet rent. And that monthly pet rent will be added to the total monthly rent that the tenant would pay every single month. Some two practice tips here. First, if a landlord agrees to allow a tenant to keep a pet or pets on the property, the landlord and tenant should check the yes box in paragraph 15 of our lease, which I will show in a moment, noting that the pet rent addendum is going to be attached to the lease. Second practice tip is a landlord may not impose a financial charge, which includes something like pet rent, to a tenant with a service or emotional support animal. So if the tenant is requesting to have a service or emotional support animal with them on the property, the landlord does not have the right to charge pet rent, does not have the right to charge an additional pet deposit, any financial penalty to that tenant. One clarification I want to make is, and the question we get somewhat often is pet rent allowed? Is it legal in Maryland? As of right now, and obviously since we made this form, it is legal. It is allowed. Maryland law has not changed to ban charging pet rent. The pet deposit, just to clarify there, technically a pet deposit is not illegal in Maryland. However, it's considered the same thing as a security deposit. And as hopefully we all know, the maximum amount of a security deposit, this was starting last October, has been lowered from 2 months rent down to 1 month's rent. So it really doesn't make sense, and it wouldn't make sense for a landlord to charge a 1 month security deposit plus a 1 month pet deposit or anything over that as a pet deposit, because that would go over that 1 month cap. So effectively, charging a pet deposit really has become obsolete. Okay, now let's take a quick look at that pet rent addendum. All right, it's a pretty straightforward addendum. It's just 1 page. First paragraph, the tenant is going to identify the pet. So we have pet name, the type of pet, how much the pet weighs, and the breed of the animal. Second paragraph, and we'll just read through this first section. Tenant shall pay additional monthly rent in the amount of X per pet. That's going to be considered the per pet rate. And tenant shall have X number of pets approved by landlord for a total monthly amount of X. So let's say they're charging $50 as the per pet rate, and the tenant only has 1 pet. So that would equal a total monthly amount of $50 in pet rent, which is due and payable with the regular monthly rent of however much that tenant's being charged for rent each month. And obviously you would add the pet rent to the total monthly rent for a total rent amount of whatever that adds up to. The second paragraph here just goes over what happens and what's the procedure if the tenant wants to add an additional pet to their lease to be able to have that pet with them on the property. It states that the tenant has to obtain the landlord's prior written consent. And if the landlord does approve the addition of that pet, the landlord can increase the total pet rent amount by the per pet rate. So if it was that $50 per pet rate, they would add on an extra $50. The third paragraph here just goes over what happens if a pet is removed from the property. So if a pet is permanently removed from the property, which includes the pet's death, so sad, the tenant shall promptly notify the landlord in writing, and upon receipt of that notice and confirmation by the landlord, the pet rent addendum shall be amended to reflect the removal of that pet. And the portion of the pet rent that's attributable to that removed pet shall be removed as of the next rental month following such confirmation. So if a pet passes away in the middle of the month and the landlord confirms that, the tenant's still going to be charged for the remaining of that month, or they're still going to be responsible to pay that full month of pet rent, but starting the next month, they wouldn't have to pay for that pet who has passed away. Yeah, so pretty straightforward addendum. And I should have said this in the beginning. We are going to get through all of the forms, and then we are going to look at the chat box, go through all the questions. So if you do have a question about this, please pop it in the chat box now, and we'll get to it at the end of the presentation. Okay, so now we're going to move on to our revised forms. The first form we're going to go over is our general residential dwelling lease template. I'd say typically most of the changes in the law that affect us and affect our forms are changes to landlord-tenant law, and that same principle applied this year, mainly because of the Renters' Rights and Stabilization Act, which went into effect last October, which require the first paragraph here. It requires a landlord to include a copy of the Maryland Tenant's Bill of Rights as an addendum to a residential lease. Also, subject to certain exemptions, the Act also provides the tenant with the opportunity to purchase or a first right of refusal if the landlord wishes to sell the property with that tenant still occupying the property. This information has been added to the lease under paragraph 10, which is titled Tenant Opportunity to Purchase. Also, paragraph 15, which is the pets/service animals paragraph, has been revised to reflect the option of adding the pet rent addendum, which we just went over, to the lease. That's where that checkbox of yes, it is attached, or no, it's not attached is. And finally, the Maryland Tenant Mold Protection Act, which became effective July 1 of 2025, so a couple months ago, now requires a landlord to provide a tenant with an informational pamphlet regarding mold risks and prevention, and to request the tenant's acknowledgement of receipt of that pamphlet. The Act directed the Maryland Department of Environment to create either, they had really two options. They can either create their own mold pamphlet to explain, the risks of mold and how to spot it, those types of things. They could either create their own, or they have the option of officially adopting the EPA's, and it's called Brief Guide to Mold, Moisture, and Your Home. So as of right now, as of today, to my knowledge, the Maryland Department of Environment has not officially adopted the EPA's pamphlet, and they have not officially created their own. So as of right now, a landlord should provide the EPA's pamphlet to their tenants. Once the Maryland Department of Environment does make an official decision, whether they're going to adopt the EPA's or create their own, we will certainly notify all of our members. So information about that has been added to paragraph 33, which we'll go over in a second. And the practice tip, this is very, very important. By far the most common call we've received on the hotline over basically the course of the last year is about the new tenant's opportunity to purchase or first right of refusal, and some other aspects of that Renters' Rights and Stabilization Act. Where do we find these forms? Who do we contact? What's the process? I want to make this very clear. Maryland Realtors does not control the process of providing with the tenant's opportunity to purchase or first right of refusal. We do not publish the forms. They are not our forms. The entity that is in charge of enforcing that process and providing the forms is the Office of Tenant and Landlord Affairs. So everybody, if you have a pen or you want to type down on your computer right now, type down Office of Tenant and Landlord Affairs. A landlord who is in the position where they have a tenant in the property and they want to list the property for sale, if they're not sure whether they have to give that tenant the opportunity to purchase or first right of refusal, they should go to the Office of Tenant and Landlord Affairs website. There is an FAQ document on there. Their contact information is on there. They also provide the tenant's Bill of Rights on their website because they're the ones who publish it. And they have, this is the most important part, they have something called the landlord portal. So a landlord who is in the position of they have to give the tenant the opportunity to purchase or first right of refusal, the landlord has to create an account on that website. By creating the account, they will get access to the standardized forms that are published by the Office of Tenant and Landlord Affairs. And the other main thing to know is after they've provided the forms to the tenant, and there's a finality, a result of the tenant's decision, they have to upload those forms back to that landlord portal to prove that they have provided the tenant with the proper rights. Also, Jackie, who is running our webinar today, she will put in the chat a link to the Office of Tenant and Landlord Affairs website, and their link to their website can be found on our forms page as well. Okay, this is our lease, and we're going to go over those changes that I touched on. Paragraph 10, the new tenant opportunity to purchase, states if landlord intends to sell the property while occupied by tenant, tenant may have the right to an exclusive negotiation period to submit an offer to purchase the property. To determine whether a tenant has the right to an exclusive negotiation period, tenant may contact the Office of Tenant and Landlord Affairs of the Maryland Department of Housing and Community Development. So giving the tenant a heads up that you may have these rights and you would want to reach out to that office. And then to finalize the paragraph in bold, landlord shall attach as an addendum to this lease a copy of the most recent Maryland Tenant's Bill of Rights published by the Office of Tenant and Landlord Affairs. So as I said, landlords are now required with every residential lease to provide that Bill of Rights to the tenant, and they can find that Bill of Rights on the Office of Tenant and Landlord Affairs website. All right, our next change is to that pet paragraph. As you can see here, we removed identifying the pet because that's going to be done in the pet rent addendum. So now in the clean version, it will just easily say yes or no, pet rent addendum attached. And then if it is, you're just going to check yes. We've also removed the pet deposit section, not because, like I said, not because it's illegal in Maryland, but charging a pet deposit has essentially become obsolete. And this lease is supposed to apply to the vast majority of landlord-tenant agreements. So we've removed that pet deposit information. Okay, and then the last change we made was to paragraph 33, which is our water, moisture, and mold paragraph. And at the bottom of that paragraph, we state, tenant acknowledges receipt of the pamphlet entitled A Brief Guide to Mold, Moisture, and Your Home, published by the US EPA, or a substantially similar pamphlet issued by the Maryland Department of Environment in accordance with that new law, that new statute. And then the tenant will initial it to acknowledge that, yes, the landlord has provided them with that pamphlet. Okay. So those are probably, in my opinion, the more complicated changes. The rest of the changes are pretty straightforward. The change to our exclusive buyer-tenant residential brokerage agreement. We revised that brokerage agreement to reorder some of the paragraphs. So the compensation paragraph, broker responsibilities, and the intercompany agent representation paragraph have been shifted up towards the beginning of the brokerage agreement. The proposal was made because those are very, very important paragraphs. And naturally, when you're sitting down with your buyer, those conversations happen earlier on. So we wanted to move those paragraphs up towards the beginning of the brokerage agreement. I'm not going to show the brokerage agreement because, like I said, it's just a reordering of the paragraphs. All right, change to our post-settlement occupancy agreement. The only change was in the post-settlement occupancy agreement, we made a revision to replace the nominal consideration option for compensation with a flat fee option. And it's easier just to take a look. So this is our post-op agreement. And these are this is the area where the buyer and seller can come to an agreement for what the seller is going to pay to have the right to remain in the property post-settlement. Previously, we had this nominal consideration option. The proposal was made to remove that and replace it with a flat fee because most agents and or consumers don't know what nominal consideration is. Nominal consideration is essentially one party paying significantly less than what something else, less than what the value of something else is. So, for example, there has to be a bargain for exchange. So, for example, nominal consideration could be paying $1 to purchase a house. Obviously, the house is worth more than that, but there needs to be some exchange of value. So that would be considered nominal consideration. It's a legal term. It confuses people. So we've removed that and replaced it with just a flat fee option. All right, the next change is to our financing addenda. So to the FHA, VA, and conventional financing addenda, they've been revised to add a section for the buyer to disclose additional financing programs that they're pursuing, such as a grant, and to require the seller to comply with requests for information from a financing program. So this is just encourages more transparency between the buyer and the seller, explaining exactly what financing programs that buyer is pursuing. I'm only going to show the conventional financing addendum because the changes to the other two financing addenda are exactly the same as these changes. So the only change we've made is we've added in an additional line here for additional financing programs. So if the buyer is pursuing, let's say, a grant program, they would disclose that in this section. And the other change was we've added in a sentence to the loan underwriting paragraph that states, seller agrees to cooperate with and timely respond to requests for information or documentation made by lender and/or additional financing programs. Just saying, if the lender reaches out to the seller or a grant program reaches out to the seller for information, they shall cooperate with that request. All right, the OSDS on-site sewage disposal system inspection and test addendum has had a slight revision. And really it's just to make it mirror the language of the water quality test addendum and the water yield test addendum. So we noticed that the paragraph that explains the notice procedure between the parties after they perform one of these tests, that notice procedure was identical in the water quality test addendum and in the water yield test addendum. But for some reason, that paragraph the language was slightly different in the OSDS inspection and test addendum. So we have removed that paragraph from the OSDS and replaced it with that same language from those two other addenda. The practice tip here is note that the actual notice procedure has not changed. So the timing for a party to provide the results and go back and forth, that has not changed. Rather, we have just took out the paragraph and replaced it with the identical paragraphs from the water quality test addendum and the water yield test addendum. And I'm not going to go through all of the language, but just know on our OSDS inspection and test addendum, it is this paragraph explaining the notice procedure that has new language. All right, and like I said, not a lot of changes. This is the last change we will go over to our water yield test notice. So our water yield test addendum states that the buyer may provide the inspection report and note deficiencies that are to be corrected by the seller only if the test results state that the water flow does not yield a minimum rate of 1 gallon per minute. In other words, the only time a buyer can request the seller to correct deficiencies is if the water flow is less than 1 gallon per minute. However, and this is the reason why the proposal was made, members noted that buyers, even though the yield was more than 1 gallon per minute, they were still submitting requests for repairs and deficiencies to be corrected. So what we've done is So that's explained in the water yield test addendum. So what we've done in the water yield test notice is that we have reiterated the buyer may only request corrective action for deficiencies that cause the water flow to fail to yield a minimum rate of 1 gallon per minute, measured in accordance with acceptable industry standards. So really just making sure and giving another reminder, hey, buyer, you can't request these deficiencies to be corrected if there is a yield of over 1 gallon per minute. Okay, that is all of the changes. Like I said, all the forms I went over today and this summary are on our website, on our forms page. So if you have any questions or you want to practice it, go take another double check. You can go to our website and find them. And now we can take a look at the chat.
Taylor, Kim and I were trying to answer some of the questions, but they were coming in fast and furious regarding pets and animals, etc. So we wanted everybody to really pay attention to what you were saying more so than us trying to answer all the questions that they were coming in.
Gotcha. So I see the first question here. Does the 1 month security deposit equal the rent or the rent plus pet rent? So the way we have drafted our lease, the 1 month security deposit should just be in consideration of that monthly rent amount. So in other words, if you are charging that tenant $1,000 per month in rent, the maximum security deposit should be $1,000. If you're charging, and this is a decision, like the statute does not specifically address this question, but in our opinion, it should not be, the maximum amount should not be, if I'm charging the tenant $1,000 per month in rent plus $50 in pet rent, the maximum security deposit should not be $10,050. It should just be, sorry, $1,050. It should just be $1,000. Does the tenant need to submit any official documentation certifying that the pet is an emotional or support animal? So I don't want to make this into a fair housing class, because we can talk, we get questions all the time on the hotline. We can talk about emotional support animals for, as long as we wanted to. But essentially, if you cannot visibly see that tenant's disability, then yes, documentation can be requested to support that request for an emotional support animal, or a service animal.
Also, Taylor, Kim had wrote a wonderful article in our magazine for April, May of this year regarding emotional support animals, and that's still available on our website and our YouTube page. And they can read that.
Next question, is there a maximum pet rent limit? No, there is not. Pet rent is not addressed in Maryland statute. It is just going to be considered rent. So it's really just a negotiation between the landlord and the tenant. What action would be needed if the removed pet or pet that passed away is replaced with another pet? And what action needs to be taken by tenant to landlord? So it just needs to be a clear communication between the tenant and the landlord. The tenant needs to explain that, pet A has passed away, and if no other pet is being added, then landlord shall confirm. I guess landlord maybe can come to the property and confirm that the pet is no longer there, and that pet rent amount would be amended and reduced. If they wanted to add another pet, a brand new pet, they would have to add to the pet rent addendum and explain what type of breed that animal is. Just go through that same process they did to get the original pet on the property. Can the annual pet rent be requested as paid in full upfront at lease signing with first month's rent and security deposit, or does it have to be paid monthly? So our stance on that is that the pet rent should be paid monthly. Because charging anything outside of that first month's rent in advance is going to be considered a security deposit. So for example, which this is somewhat common, or at least it was in the past, charging last month's rent in advance is considered a security deposit. So if a landlord is going to do that, they have the right to, but they would not be able to charge last month's rent in advance plus a security deposit, because that would put you over that 1 month's rent cap. So yeah, to summarize our answer, pet rent should be paid monthly, as like all the rest of the rent is. It should not be paid in a lump sum. Does the pet rent release them from damage that exceeds the pet rent amount? No, it does not. So if you have a tenant and their dog, does thousands and thousands of damage to the property, and of dollars in damage to the property, the tenant is going to be liable for that amount. So you can apply the security deposit to it. Obviously, you are collecting pet rent. But if it exceeds the security, if the damage exceeds the security deposit, it's up to the landlord to make a decision whether to pursue that additional amount in court.
Taylor, I think we have one more pet question about pet references. I don't think the law addresses pet references.
Can you request pet references? No. You're right. The Maryland law does not address that, so I shouldn't have said no. Yes, a landlord can request pet references if they want to. However, if it is an emotional support or a service animal, you cannot request pet references. You can only request documentation that proves that, yes, this tenant does have a disability. Regarding the EPA pamphlet, I'm assuming for mold, is this regarding to new tenants, or are the landlords expected to go back and give this form to all tenants? So the law does not require the landlord to go. So for example, if a tenant signed a lease 2 years ago, the law does not require that landlord to go back and provide the pamphlet to that tenant. Starting July 1st of this year, landlords have to provide that pamphlet. Now, does it hurt to provide that tenant with the mold pamphlet? I don't think so. I think it's good that all parties understand what mold is and how to spot it, all those types of things. So I see a question somewhat similar. If the lease started post July 1st of this year, then all of that information, the tenant's bill of rights and the EPA mold pamphlet, should be provided to that tenant. I have a question here. When will the new forms be uploaded and available in zip forms? They will be available on October 1st. So on October 1st, on our website, all the forms will be officially published and ready for use, as well as all of our licensed form vendors. They've already been provided with the forms and instructed to release them on October 1st. I see a proposal. Can an acknowledgement of receipt of that tenant's bill of rights be added to the lease for tenants to initial? Yeah, let me we can certainly take that proposal to our statewide forms committee. Right. I see a question from Isabella here. Is there any move to create a specific rental addendum to cover tenant broker compensation offered by a landlord like we have for buying and selling? So I'm assuming you're talking about a situation where the landlord has either the landlord themselves or actually, excuse me, the landlord has authorized the listing broker to offer compensation to a buyer broker. We made a revision, can't recall exactly when, but we did notify everybody. We made a revision to our listing broker's offer of cooperative compensation form. And in that revision, at the top of that document, we made a revision to note that any reference to a listing broker or a landlord, any reference to a seller shall mean the same thing as a landlord, and any reference to a buyer shall mean the same thing as a tenant. So in other words, you can use that form if a landlord has authorized their broker to offer compensation to a tenant's broker. Going through, you guys see any good question? I'm seeing a lot of already answered questions.
Taylor, did you already answer the question about, I may have missed it when I was looking at other things, about adding an acknowledgement of the provision of the Bill of Rights in the lease?
Yep.
Okay.
Yep, I made note of that. That'll be presented to the statewide forms committee. Bob Pettis said, any addenda regarding disclosure of wholesaling transactions? So we have not created an addendum or changed any language specific to that disclosure. It's important to note that our standard contract of sale states that if the contract is going to be assigned, the buyer has to get permission from the seller. Our contract as it is non-assignable. So if that contract is assigned, it has to be get the permission of that seller before it can be assigned. I see Mike Cerrito, and this is a good information that I didn't know because we try to operate at the state level. Mike says there is a maximum pet rent limit in Prince George's County under a new law. So remember, our general residential dwelling lease template is just that. It is general. It is supposed to apply generally statewide. There are certainly instances where there is a county law that might impose something like this, a pet rent limit on on a landlord. And this is another good question. Another pet question. Can you pass on a one-time pet charge? Like a one-time charge for, it keeps going away. DNA pet waste management to do the DNA testing. So if it is a charge that is not a monthly charge like a pet rent, if it is something that is charged before the tenant enters the property, like a $500 pet fee, in our interpretation, that is going to be considered and fall under the definition of a security deposit. So if by charging that pet fee or pet charge, if charging that plus however much you're charging for a security deposit, if that amount goes over 1 month's rent amount, it would be in violation of Maryland law. If tenant fails to pay pet rent, is that means to evict? And if tenant fails to notify landlord of additional pets, can they evict? So 2 questions there. If tenant fails to pay pet rent, is that a means to evict? So pet rent is going to be, as it says in the addendum, added to the monthly rental amount. So tenant is liable for that, just as the same as if they're liable for the regular monthly rental amount. So it is possible if a tenant fails to pay that pet rent, it is possible that they could be evicted if they do not pay, but you have to go through court before that can happen. And to address the second question, if a tenant fails to notify the landlord of additional pets, can they evict? It does state in the addendum, and I believe also in the main lease, that failure to get approval to have pets on the property is considered a breach of that lease. So it could possibly result in that tenant being evicted. Buildings with 4 or more units would be commercial. Financing, eliminating your rental forms. Not sure. I don't really understand that question. What if the pet dies and you get another pet in the time frame of your lease? Can a landlord say no? Yes, a landlord can say no. If it's a brand new pet, you're going to go through that same process and explain what the breed is, how much the pet weighs, and you need permission from that landlord to get that additional pet in the property. Mackenzie Hoffer states a good question that we get a good amount. If someone wanted to pay a tenant, wanted to pay their entire rent up front, they would not be allowed to. So this is important to know that in Maryland, and there has been case law on this, and this is what the case law says, if a tenant who is unprompted by the landlord offers to pay additional rent outside of 1 month in advance, let's say they want to pay a year's rent in advance, the landlord can accept that. What the landlord cannot do is the landlord cannot ask the tenant to pay additional rent in advance outside of the first month's rent. So it's an important distinction there. So Kevin, Kevin Waterman, your question is a little, it's going to require a little, an extended response. So please send that through our legal hotline and we'll get you an answer.
Taylor, there was a question there by Kathy O'Doherty. Are the landlords required to give the physical forms of the documents, or are the electronic versions acceptable?
I believe so. I'd have to double check our lease to see if it does address electronic delivery and gets consent from the tenant for electronic delivery. However, I think by providing an electronic copy of the tenant's bill of rights, in my opinion, that would satisfy the requirement of the landlord.
Exceptions saying no. Yeah.
A lot of repeat questions.
Taylor, I see one from Laura Fager that says, if a buyer applies for a different grant program and the one identified in paragraph 1, is that considered alternate financing, even if the terms of their first trust mortgage is the same?
I don't think that's going to be considered alternate financing. I'd like to think about that a little longer. I don't think it would be considered alternate financing, but if they are pursuing a different grant program, that information should be provided to the seller, and it could be accomplished through that new line in the financing addenda.
A question from Brooke that says, is it permissible to cross out the 1 gallon and put something else there in negotiations and thus could report it?
So like all of our forms, they are our standardized forms. The 1 gallon rate, that was obviously approved by our forms committee at some point in the past. We always discourage agents from striking through or adding additional language to our forms. If the seller and the buyer want to come to some different agreement, it is up to the seller and the buyer. If they want a 3 gallon limit, it's up to the seller and the buyer to come to that agreement. It's negotiable, as is almost everything else in our contract of sale. Beverly asks, what are the repercussions to a landlord if they do not give the tenant the 30-day first right of refusal? So before I give an answer to that, I want to reiterate, it is the Office of Tenant and Landlord Affairs who's in charge of this process. That's why we really don't like addressing questions about it, because they are supposed to be the experts. So any questions about that process should, going forward, be submitted to them. However, I know the statute does say a landlord who fails to give the proper either tenant opportunity to purchase or first right of refusal can be subject to a fine of up to $1,000. The landlord require that pets be up to date on rabies shots, etc. Yes, they could. I am not, actually, this question, if a landlord does not provide the mold information, what is the penalty? If I recall correctly, I don't think the statute specifically did state a penalty. And typically in a case like that, if the statute does not specifically state a penalty, it's going to be up to the court to decide a penalty. And since this is a brand new law, we obviously don't have any cases about it. So to be continued there, I guess we're really not sure.
Just to remind everyone too that if you missed something, because we were going through, as Taylor was going through it, and people were entering questions in the chat, if you feel like you've missed something, you can reference our summary of changes that Taylor put together that's on our website, and it spells it all out for you there. So if you think you may have missed something, please go back and check that summary of changes and practice tips, and your answers will be right there.
Can landlord request first month's rent be delivered prior to the lease start date? Yes, they can. But only that first month's rent. Can a landlord deny a certain breed of dog but allow other breeds? If it is a pet, yes. There's no restrictions on the landlord for denying or accepting a pet. But if it is an emotional support animal or if it is a service animal, the landlord cannot deny the animal based on the type of breed, for example, the breed of the dog that the animal is. Doug Smith, can you do me a favor and email me your question? It's going to take a little longer to dive into your question to give you a good answer. How long does a rent? This is the last tenant first right of refusal opportunity to purchase question that I'll address. How long does a rental property have to be vacant after the tenant moves out before the landlord can sell without a first right of refusal? So if you're specifically talking about a first right of refusal, that means the landlord and tenant, that means the landlord offered the tenant the opportunity to purchase, and they could not come to an agreement. The property was listed, and then that landlord got another offer to purchase the property. There's no time limit on when that first right of refusal is gone, but it's only triggered if that landlord is intending to accept a second offer, let's say, that is 10% less than what that tenant last offered for the property. So in other words, if the tenant's last offer was 500,000 and landlord and tenant couldn't come to an agreement, and then later that landlord receives an offer for 400,000 that the landlord wants to accept, that's when that first right of refusal is triggered. And the landlord has to reach back out to the tenant and provide them with the first right of refusal to purchase the property for 400,000. The question is, if the pet does $5,000 in damages, but the tenant paid $2,500 in pet rent, are they only responsible for $2,500 or the entire $5,000? So they would be responsible for the entire $5,000. Pet rent is not, it's not a security deposit. So it's not going to be a sum of money that is going to be applied to damages. It is considered an addition to the monthly rent. So a question here, they say that there are Maryland counties that prohibit specific breeds, like a pit bull. That is true. However, and this is guidance from HUD, if that pit bull is a service or emotional support animal, the right of that tenant with the disability to have that pit bull in the property trumps that local county law. So if it is a legitimate service or emotional support animal that is a pit bull, the landlord must accept that pit bull, even if there is a breed restriction. Now, it's a good example of, sometimes federal law, local laws, they conflict, and how do you handle it? It can be a complicated situation, but that is the answer that HUD has provided. Same goes for insurance as well. All right, I'm not seeing any new questions. If for some reason I missed your question, or you have a question pop up in your head after we log off, please feel free to email or call in to our legal hotline. We're open from 10 to noon and 2 to 4, Monday, Wednesday, Friday. So please feel free to shoot us your question, and we'll get you an answer as soon as possible. All right, and just as a final reminder, everyone will receive a copy, a video copy of this webinar in their email after we leave. Also, a copy will be uploaded to our YouTube channel probably within the next day or so. And finally, all the sample forms and summary of changes that we went over today, they are on our statewide forms page at the very top. All right, I'm going to stop my share. Jackie, is there anything else we got to do before we get out of here?